Ready, start. Pius C. Kuriakose under challenge in this revision petition filed under Section 20 of the Act 2 of the 1965 filed by the tenant is the judgment of the Rent Control Appellate Authority confirming order passed by the Rent Control Court dismissing his application to set aside an ex parte order of eviction passed against him. The case of the revision petitioner tenant was that though the correct posting date of the RCP was 11/6/2008, the registered clerk of the advocate who was appearing for him before the Rent Control Court noted the same mistakenly as 13/6/2008. Therefore, neither he nor his counsel were present on 11/6/8 when the case was called by the Rent Control Court, leading to the passage of the ex parte order of eviction. The Rent Control Court and the Appellate Authority, however, did not become inclined to accept the explanation offered by the revision petitioner in bracket tenant for his absence on 11/6/2008. This was because in the memo which was issued by the tenants council against payment of a sum of rupees 1000 which had been ordered by the rent control court as cost for granting adjournment of the RCP, the posting date was noted as 11/6/2008 itself. According to the Rent Control Court and the Appellate Authority, in the teeth of that memo, wherein posting date is mentioned as 11/6/2008, it is ideal for the tenant to contend that the posting date was noted wrongly on 13/6/2008 in the diary kept by the clerk of the council. Para. Sri P. Martin Jose, the learned counsel for the revision petitioner, and Sri Rajkumar, the learned counsel for the landlord, have addressed us extensively in support of their rival positions. It has been noticed by the Rent Control Appellate Authority itself in its judgment in paragraph number 8 that courts are expected to take a liberal approach while dealing with applications for setting aside orders ex parte. The policy of law is always that causes should be allowed to be adjudicated on merits rather than decided on technicalities. We feel that explanation offered by the revision petitioner that the clerk of his advocate in the court below noted the posting date wrongly as 13/6/2008 and that his counsel's absence on 11/6/2008 when the case was called was due to such wrong posting date noted by the clerk is not a totally improbable one. We feel that probabilities are equal when examining correctness of the rival version. Having regard to the principle that causes should be adjudicated as far as possible on their merits, we give the benefits of doubt to the tenant. At the same time, we are not inclined to grant such benefits unconditionally. The result of the above discussion is therefore as follows. The order of the Rent Control Court and the judgment of the appellant authority dismissing the application filed by the tenant will stand set aside and IA number 477/8 in RCP 2/07 will stand allowed subject to the following condition. The revision petitioner pays a sum of rupees 6,000 in bracket amount equal to 1 month's rent payable for the building bracket close to the respondent either directing or through her counsel in this court within 7 days. Revision petitioner will pay a further amount of rupees 1000 to the Kerala Mediation Center within the same time limit through its nodal officer. Para. The order allowing IA number 477/8 will become operative only if both the payments are made on time. The revision petitioner is permitted to file memos against payment of amounts before the rent control court. Once the rent control court notices the memos, that court will specially list the RCP number 2/7 in the month of October 2009, if necessary, by publishing the additional special list for the purpose, and ensure that the RCP is disposed of on merits by the end of October 2009. It is made clear that if amounts are not paid as ordered above, the impugned order and judgment will stand confirmed and the RCR will stand dismissed. Stop.